this session is intended to bring all those documents closer to you and bring them home. All right. So let's start with some of the first phase of the questions there. The Council of Europe is not one of the European Union institutions. It's a totally separate institution. Many people mistake it with the European Union. Many people think that it's one and the same thing. It's actually the Council of Europe that came together first, and then the European Union later. So the Council of Europe was formed in 1950, whereas the European Coal and Steel Community, or whatever it was called at the time, came about in 1957, and it was an economic union until much later. Okay, so it was no more than an economic union. The Council of Europe, on the other hand, was a human rights union from the very beginning. And all of the institutions there, so the Council of Europe, the EU, and the United Nations, address trans rights to some extent. When I say to some extent, it's because they don't all have the same competencies or the same resources, or have put the same set of institutions available, right? So while, as I say, the Council of Europe was there as a human rights institution from the very beginning, with the European Convention on Human Rights already adopted in 1952, if I'm not mistaken, the EU came to human rights at a much later stage in its development. And still, to this day, its human rights work continues to be related to its economic work. So human rights have to be justified in terms of freedom of movement, for example, of goods and services, and of people and so on, or cross-border dimensions, okay? There are, of course, a set of human rights that the EU is approving that have a greater impact, but by and large it still remains an institution that regulates, if you will, cross-border situations, not so much intruding into domestic legislation, okay? So the EU does not say, just to give you an example, all member states of the EU should adopt marriage equality legislation, or the EU will never say all member states of the EU should adopt legislation on change of name and legal gender, right? It won't say that. Maximum it will do, at least at this current point in its development, is to say whoever changed legal name and legal gender in one country should be able to go in each and every country and have that legal name and legal gender recognized wherever. That's the maximum it can say. You see that this is the difference. And then fifth point there was international human rights institutions recognize gender identity as a ground of equality on equal footing to race and or sexual orientation. That is not the case for any of those institutions that I mentioned so far. So gender identity is increasingly gaining ground as an increasingly recognized ground of anti-discrimination, but it's not been elevated to, surely not the status of race as a ground of anti-discrimination, or sexual orientation, which is not equally recognized as a ground in itself, but nonetheless is fairly recognized as a ground of anti-discrimination. Is this clear how different grounds have different status in front of these bodies? For example, submit a UPR submission to the United Nations and have gender identity elements covered under there. Likewise, a CEDAW submission, Convention on all forms of discrimination against women, for example, and trans people are expressly covered under that. So there is a growing body of text of all those institutions, which I think is significant, because until a few years back, we wouldn't have been able to say this, right? So this is why I put it there. I had a question.
You should be careful when you use the wording gender identity, since quite often it's used when there is any protection, it's used in a very narrow sense, meaning only people undergoing gender reassignment rather than trans people at large. And therefore, and unless you see the wording gender identity, you can't automatically assume it means gender identity.
Correct.
You have to be careful and figure out what is the exact wording.
Correct, but the same institutions sometimes use the words interchangeably, and that is a good thing for us because it provides an opening. Just to give you an example, well, the Council of Europe and the United Nations in their recommendations and resolution have referred to the wording gender identity, so that is positive, is good. The European Union still refers to gender reassignment. However, if you look, for example, at documents, recent documents, for example, the gender equality strategy, for example, they refer to gender identity in the monitoring of the gender reassignment elements of the legislation, right? It's language that we are pushing, and we should continue pushing. We should not settle for the lowest common denominator, but the highest, and try to say this is the new standard, this is what we should be aiming at. Now, next set. So the next set was addressing different human rights documents. I'll read them out for you. I know for those far away. So the Yogyakarta principles, as good as they are, they're only a source of moral authority. In some countries, you can claim a bit more, like in the Netherlands and Belgium, where, for example, the parliament has approved them, or they were discussed at a high level, ministerial level, for example, and the country has adopted them as the set of principles on which it's progressing the LGBT agenda, okay? In most other countries, this is not the case. So the Yogyakarta principles is
Belgium
good,
and the Netherlands.
but also some other countries. I don't have the full list, but some other countries have had them discussed at different levels of government, okay? The Hammarberg issue paper, once more, unfortunately, as good as it is only a source of moral authority. By that I mean you can't just go to your government and say, this issue paper is saying that you should do this and this, why haven't you done it yet? It just doesn't have that standing, okay? So as good as it is for you to back up your argument when you advocate domestically, for example, for removal of any surgical requirements or sterility requirements for change of legal name and gender, for example, it's great for that purpose, but you can't use it in a court case to have leverage there or anything like that, okay? So use it with caution is what I'm saying. Use it as much as you can, but don't try to have it as your primary legal argument, because it will not work out, okay? Gender equality legislation coming from the European Union is legislative. So the unfortunate thing about those laws, both directives there that are mentioned, is that they don't refer to gender identity per se, at least not yet, okay? So the Gender Recast Directive dealing with employment has gender reassignment mentioned in the preamble, that's it. The Goods and Services Directive doesn't even have that, but it still covers gender reassignment, okay? So because of the fact that both cover gender reassignment, you can use them if you come from an EU country or are residing in an EU country to progress a certain agenda when it comes to equality in employment or access to goods and services, including healthcare, okay? The European Convention on Human Rights is legislative, but your country needs to ratify it. You all come from countries that have ratified the European Convention on Human Rights, so you can all refer to the European Convention on Human Rights, and we'll come later to the cases that have been decided by the European Court of Human Rights and the rights provided domestically, okay? So that is also a good thing. Some of the protocols are have immediate effect, other protocols need ratification. So for those protocols, for example, Protocol 12, which is the Equality Protocol, your country needs to access it directly, okay? And not many countries have done that yet. So that's also another lobby opportunity that you have in your country, Protocol 12, the Equality Protocol. Then European Court of Justice case law, so this is the European Union Court, has direct legislative effect. So for example, the moment P versus S and Cornwall County Council was decided by the European Court of Justice, it had direct effect in all member states of the European Union. So all member states of the European Union had to deal with cases and issues of transsexuals at the time, and still is the case, in access to employment, all right, and dismissal and so on. So if a trans person was dismissed from employment on the basis that that person is trans, for example, directly like that, or indirectly but clearly related to the gender reassignment of the person, then this this court decision had effect in all EU countries. Okay, the same case is not, however, working exactly like that with the European Court of Human Rights. So the European Court of Human Rights hands a judgment that is very authoritative and has an impact in the country where the judgment, where the case came from. Okay, so just to give an example, a UK case claiming discrimination of transgender people who don't want to undergo gender reassignment procedures, for example, because they can't change identity documents, for example, okay, in the UK. The European Court of Human Rights in the future will decide on such a case and say, yes, they are right, and they should be able to change identification documents without undergoing certain procedures. And that decision will have effect on the United Kingdom, but not necessarily in the rest of the of the Council of Europe member states, automatically like that. If other cases, however, come from Turkey, from Georgia, from Italy, from wherever, okay, claiming the same right, the same decision will be taken also against Turkey, Georgia, Italy, whichever country, okay? And then once a precedent is established, then it really applies for everybody. But it's not automatic like that. All right. Then the Council of Europe Committee of Ministers, Sexual Orientation and Gender Identity Recommendations, there it's tricky. I think it's more soft law that you should have chosen, but moral authority is equally good. But once more, it's not. It does not have immediate effect. It's not enforceable domestically. The Parliamentary Assembly Sexual Orientation and Gender Identity Recommendations, that's soft law. The UN Human Rights Council resolution on human rights violations based on sexual orientation and gender identity, that's soft law again. It does not have a legal effect. Universal Declaration on Human Rights. Many of you may think it's just a declaration, but it's more than that. That is legislative. The unfortunate thing about it is that the UN mechanisms are weaker. Okay, so taking a case through the UN mechanisms is not gonna give you the same effect that the European institutions give you.
So this have to be ratified by the countries?
Yes,
Yeah.
but all of your countries have ratified it for sure, because otherwise they cannot accede to the Council of Europe, and otherwise they surely cannot accede to the EU. So there is that level of there's that mechanism in place as well. The Convention on the Elimination of All Forms of Discrimination Against Women is legislative and after ratification. That has been adopted by virtually all states in the world. This is important for various reasons. It gives you, in a way, the scope of legislation that is available, which is falling under which institutions. So the EU, the Council of Europe, UN, they're all useful in different ways. But also it gives you a perspective also on how much you can expect from the different pieces of law. The more authoritative they are, so the more they have direct effect, the more you can invoke them domestically and say, in your country therefore, and say, the EU directive says this and this, so in our country I don't have that right, this has to be changed. That is that's an easy statement to make, okay? Because if, for example, the EU directive guarantees that you should have an equality body dealing with gender reassignment issues, and you don't, then there is a problem that you can address domestically in your country by saying, we should have this, we don't have this. We want it, things have to change, okay? If it's, however, a principle that is found in the recommendations that we will be discussing in greater detail in a bit, then that is less obvious. You will have to do more lobbying, you have to address your government differently, okay? Soft law. Soft law is something that has moral authority, that is somewhat enforceable because the states have given consent to. So just to give you an example, okay? The Commissioner for Human Rights put together the issue paper on human rights and gender identity out of his own will, and of course he consulted legal texts and brought into that document case law and so on, but at the end it's his opinion, if you will. You know, no one endorsed it, he just put it out as a document with the hope that it will have legal impact as well as social impact, okay? That's one kind of document. It only has moral authority because he's the Commissioner for Human Rights. If it was you and me, then it has not even that, okay? Not even that moral authority, because we don't have that authority in European society. The recommendations that we will be speaking in greater detail are soft law. Why? Because every member state of the Council of Europe, so that's 47 member states, approved those recommendations. They said that they were going to do something about sexual orientation and gender identity in their respective country. Now, it's either because they were pressured to do so, they did not want to appear like the only country in the whole of the Council of Europe opposing them, or because they are really believing that this is the way forward. That in a way doesn't matter to us anymore, right? And they've approved those set of recommendations. They have signed up to them also by approving them. So now it's for us to ensure that soft law, which they didn't ratify or do anything more than that, okay? They just gave their word that this set of recommendations are fine for them. And it's up to us now to make sure that soft law has impact in each and every country. So I think some things need to be said about all those documents that we've just had a quick review of. Express reference to gender identity in human rights law is very rare to start with, but any such reference is very recent, okay? So that's a statement of fact there. However, in spite of the difficulties in the past, we're gaining a lot of ground and visibility. So all of us have to be happy here and be proud of being part of a historic change, a major historic change that's happening as we speak in terms of gender identity and gender expression. This is all new. If we went only 3-4 years back, there wouldn't be any of the references that there are currently. So, and back to the three main institutions, the UN Human Rights Council resolution demanded a study on violence and discrimination against LGBT people worldwide. So that is to be discussed by the Human Rights Council in 2012. That's going to be interesting because, for example, Turkey will be an interesting example there. What is Turkey doing on addressing violence and discrimination of LGBT people? So it's not only about other countries in Africa or Asia, but also countries within Europe will be getting an interesting review, I think. Russia and other countries outside of the EU, what's happening there, Ukraine, you name it, okay? But also Lithuania, for that matter, what's Lithuania doing, and so on, okay? So it's going to be an interesting review, that one. The EU Fundamental Rights Agency has commissioned a study on violence and discrimination against LGBT people within the EU. So that is expected to start, that study is expected to start later this year, and a report will be coming out at the end of 2012. It's going to be an interesting study, that one, because it is meant to survey the experience of discrimination and violence by LGBT people in Europe. And suddenly there will now be statistics attributed to that discrimination and the violence, okay? So there will be parallels also that can be drawn between, say, Sweden, Spain, Cyprus, Bulgaria, okay? Who is doing what on which front, who should be doing more on which front as well. So that's an interesting outcome of the previous studies that the agency did in the past. And then the Council of Europe Committee of Ministers recommendations on LGBT rights will be, and their implementation will be examined in March 2013. So between now and March 2013, all of us have a role to play in making sure that the best reports are drawn up to illustrate where the countries are failing the implementation of those recommendations. So, in short, and I really believe this, I didn't want to just put it there to say, yes, we're doing great, but in short, I think there should be no pessimism whatsoever in this room when it comes to international trans rights activism, because the growth has been enormous, okay? I think, as a ground of anti-discrimination, it's one of the fastest growing grounds ever, in terms of recognition and in terms of actual institutional action. Some of you would say, yes, of course, but we are the last ones on the block, right? We should have been there 50 years ago, maybe. Maybe so, okay? But nonetheless, in terms of growth and recognition, it's outstanding. So we should recognize that, know that we're participating in that, and continue participating in that to make sure that, what we've managed to advance, we will continue to advance.